Our next case is Citizens Insurance versus Livingston County Road Commission. Good morning. This is a 15-minute mini oral argument on the application. You both may have 2 minutes of a fire-free zone, and you may reserve time for rebuttal, but we ask that you keep track of that yourself.
Okay.
And you may begin when you're ready.
I just want to set my timer.
I'll probably remind you.
You'll time it?
Pardon?
Good morning, Your Honors. Larry Bennett on behalf of the Livingston County Road Commission, and thank you for the opportunity to be here today to answer your questions. Because of their impact on Michigan law, it is imperative that the errors in the Court of Appeals opinion get corrected and the undisputed facts establish those errors. And here they are. There is no signed contract. The contract, which defendants say was entered on August 30th, 2019, specifically states it is not effective until it is signed by the signatories, and the signatory is LCRC, and there is no LCRC signature. There are no minutes of or any other evidence of any legal or even illegal meeting approving the settlement or granting Mr. Stapleton special authority. That is conceded on page 11 of the plaintiff's supplemental brief. Not only are there no minutes giving authority, there are no communications that the LCRC has giving Stapleton any authority to settle this case, and that's answered in our discovery. Once the court below narrowed the broad scope of the request, LCRC answered and said there are no communications. And it is also undisputed that the only evidence the plaintiffs have and offer in support of their claim that Stapleton had special authority is one email from him, which, by the way, was concealed from us until the complaint was filed, which was sent surreptitiously to the defendants on December 10th, after the LCRC had already rejected the contract on its merits, stating that he had authority because he talked to lawyers in the underlying environmental case. This was what we're involved in here is a DEC action regarding coverage for an underlying litigation involving environmental contamination. So there are two components. One is an amount, and one is the release terms. As to the amount, Mr. Stapleton says he had authority coming from a closed meeting. We all know that doesn't give him a proper authority. But we don't have to focus on that component because he said the authority he got with respect to the language of the release came from discussions with those lawyers. He never said he had authority from the LCRC. In his email, he says, I did have authority from the LCRC. And the Court of Appeals glossed over that email by saying, Mr. Stapleton's email raises a question of fact because he said he has authority from the LCRC. That's not what he said. He said, I had discussions with the lawyers. So there is no showing at all that the LCRC gave any authority, legal or illegal. So we also think it's important to stress that we didn't know about this email by Mr. Stapleton until we received it in the complaint much later. Because the plaintiffs say we raised the issue of Mr. Stapleton's authority when we rejected the settlement. That's not true. We had no idea he had made that claim. Those emails were kept from us, and Mr. Stapleton even thanked the plaintiff's counsel for not sending it to us pre-litigation. So when we look at what evidence there is with respect to what LCRC did with respect to the claim of no authority, all we did was defend an allegation made in plaintiff's complaint. We rejected it based on the merits. We get a lawsuit that says Mr. Stapleton says that he had authority to enter. So now our theory is we had a settlement back in August. They never said that during the correspondence in August, September, and October. What they said back then was, well, we would expect you to have minutes approving this. And we've given you, this is laid out with the, the documents. Back then, they knew, the plaintiffs knew, or the plaintiffs' counsel knew, what everybody knows. The LCRC can only act if it has a public meeting where there's an opportunity for the public to participate, and then the only authority can come from that public meeting. Only after, and that's all the correspondence in September, October, and November. Only after Stapleton sends this surreptitious email do they now claim in a complaint, wait a minute, we had a deal with Mr. Stapleton. But there's no evidence to support that. And that's why when we were fighting this, we said not only should we quash the discovery request and the subpoena, we should get summary disposition. There simply is no evidence to support this claim. We didn't raise the authority issue originally. They raised it. I was litigating this. We denied the allegation. That's all we did. But then the court rules say if you have a defense that eviscerates the plaintiff's claim, you have to plead it. So I not only denied whatever their numbered paragraph was, I added it as an affirmative defense. But that didn't initiate that issue. The issue was raised by their allegation, which, by the way, is made without any factual support. So that can't result, in our view, in a forced waiver. And here's the difference. In the other cases where a position taken by a party results in a waiver of the privilege, it's an evidentiary issue. Whether somebody did something that's relevant in a probation report, or whether somebody's claiming attorney-client privilege as part of the defense. Those are factual issues. This goes to the very heart. And we shouldn't have to waive our attorney-client privilege to answer an allegation for which there is no factual support. We have to keep going back to that. They got nothing that says Mr. Stapleton had authority beyond having discussions with attorneys not even involved in this specific issue. And here's why we have an issue that's before you. Like I said, once the discovery was narrowed, we answered, because there is nothing. Mr. Stapleton was subpoenaed. He swooped up his entire file and said he was subpoenaed to produce where he got his authority. He just swooped up the whole pile. Since it's our privilege, I asked for the right to review it to see if there were attorney-client privilege materials. When I looked at it, there's nothing there that gives him authority, but I felt that I could not go to him and tell him there's nothing here. I thought that that could be construed improperly, that if this is what he says, and I say no, I don't feel that I could go to that witness and attempt to affect what he thought was the response to the subpoena. But that's why we filed the motion for a protective order and a motion to quash, was to keep those attorney-client privileged emails privileged.
Counsel, I'd love to just jump in for a minute. I understand the difference of opinion on whether the attorney had special authority and all that. Let's just assume I think he did. And that's just an assumption, because I want to get to the next issue of sort of the Open Meetings Act. I know we have differing opinions on whether the Open Meetings Act is sort of self-executing or whether a lawsuit has to be filed to enforce it. I know we also have these old Court of Appeals cases that this Court of Appeals relied on, basically saying that an attorney can have special authority even if it's a public body. I will admit I find that a bit of a troubling holding, given public bodies and how they exist and democracy and all that. So I'm just curious how you think we should deal with those cases, realizing they're old cases.
So I think what you're asking me is, the Nelson case says just hiring an attorney gives them authority. My first answer is that can't possibly apply in the government situation. We all know, everybody who's practiced for any period of time, and I would think Judge Viviano you had to have dealt with that, and sometimes it's frustrating because you can't get people in front of you who actually have authority. We all know it's subject to the commission's approval or whatever board is involved. So that's my first answer. I'm not sure you have to address that here. But secondly, there are a lot of cases that say, no, you can't do that. And I printed out a list of them. There's a lot of court of appeals that say the mere hiring of an attorney doesn't give them authority to settle a case. In anticipation of this question, I did some research to see, well, what's the view around the country? And I can't say it's exhaustive, but there was a University of Alabama law review article that said, no, it's not the majority view and it's not proper. By far the majority view is an attorney doesn't have authority unless it's specifically given to that attorney. The mere hiring of an attorney doesn't give them that. There's a recent California case that deals with the ethical issues that are raised by that. If an attorney can go settle a case, it's contrary to some of the ethical obligations that attorney has. It's a pretty long opinion dealing with the ethical issues. But lastly, it's just a bad policy. We can't have attorneys that can go settle cases. And I think the counter view is, well, if we can't rely on the lawyers, then that could be a problem for the system. But the fact is, we don't rely on the lawyers. Good practitioners and even good courts say, if the lawyers report a settlement, they want you in that courtroom with the clients. In other words, the night before trial, you say, Judge, we settled the case. See you tomorrow morning. Be here with your clients to put it on the record. So then you comply with 2507. I don't think it hurts the system at all to say that the remedy for a client whose lawyer settles the case without their permission is for them to sue. I don't think it's bad for the system to say that's a terrible remedy. It's terrible for the public, it's terrible for that plaintiff, and it just fosters more litigation when the simple solution is, unless you got evidence of authority, you better get the correct way to resolve a case. But I come back to, I don't think you need to do that with a governmental entity, because everybody knows that unless there's a meeting giving that person special authority, and that's what the Presnell case says, it could be that there was a meeting not approving the settlement, but giving the lawyer special authority to settle. That's not present here, and there's no allegation that there is.
Doesn't the Presnell case make it pretty clear that if you're going to have some type of prior authority, which would seem to me to be pretty unusual, but it says either by statute or by resolution of the board?
Correct.
So is there a way for the board to secretly confer advance authority on their lawyer to settle a case against a governmental body?
No. Well, the answer is yes, but they can't give them the authority to settle. But lots of times there's a meeting in private that says, look, if you can get them there, just like you do with a regular client, if you can get them there, we'll likely approve it. But we can't give you that authority in this closed meeting, and we don't want to go out.
As a trial judge, I would, if you were settling these cases against the township board, for example, we'd have to have a majority of the board, I think, at the settlement conference.
And you can't do that. I think there's a case. We tried to find it. I remember this happened in Wayne County. A judge got aggravated because there was nobody there with authority. And he issued some sanction, but it went up and said, you can't have them there, and this is why, Your Honor, they have to have a public meeting.
Right.
So there's strategy sessions and closed.
So we would have to wait until the board meeting happened.
And it happens all the
settlement would be
time.
approved.
That's life working against governmental entities. And, the practical answer is, and I wanted to leave a little time, so the practical answer is usually...
Isn't that, I don't mean to cut you off, but isn't that the answer to your attorney-client argument? That even if there was some secret email from the board that said to the lawyer, you can do X, Y, Z, that's not enforceable?
Right. Doesn't give them authority. And they knew that. They kept saying, where's the minute? We need a meeting. And we're sure, Mr. Stapleton, that you have minutes. So what they say is, we came in and the settlement was rejected. Stapleton said their position is wrong. I had authority to settle this case. And the plaintiff's counsels respond, well, we assume you would have minutes. And he writes back, and he doesn't say he has minutes. He writes back and says, I had discussions with a couple of lawyers about what would the language be, and then we will submit it for approval and signature. Not signature, approval and signature. I got 1:12.
May it please the court, Michael Cook on behalf of citizens and Amerisher, and with me at council table is David Nelson, who represents auto owners. For better or worse, he's decided to yield his time to me, so I'll proceed. The summary disposition issue, I think is pretty clear, comes down to authority. Can a governmental entity settle a claim before a suit's filed? Sure, absolutely. That's inherent in the fact that it can sue and be sued. Can it authorize an agent to enter into a settlement? Yeah. Just like any other entity, a governmental entity only operates through its agents. Can it authorize an agent to settle in violation of the Open Meetings Act? Yeah, they can. Is that automatically invalid? And if you're looking for an interesting issue in this case, that's the one. And I think you've already answered it in Spiker. You said there are specific and exclusive remedies under the Open Meetings Act. One of those remedies is how to invalidate a decision of the board. And that's through a court action. That hasn't happened here. So whatever they did, if it is in violation of the act, hasn't been invalidated yet. So if it's not invalid, they can authorize, they can settle, then it comes down to, did they do that? I don't know. We don't know yet. We were in the process of litigating that non-discovery, and we haven't completed discovery to find out, did they actually give this authorization that their former attorney says he had? And that's really where the summary disposition ruling comes at this point. There seems to be evidence that there might be some authorization for him. And so the court denied summary disposition. A couple other issues that the courts haven't reached in the lower courts is apparent authority and ratification. I think there are questions of facts on those. The apparent authority is different from express authority in that the principal has to do something that would suggest to the other side that their agent has authority. And so here, I think you can confirm that in saying there's a question of fact by looking at the resolution they passed. They confirmed that, it's suggested in some briefing that the former attorney went rogue in setting up these facilitations going to him. The resolution they passed in November said, yeah, we authorized this. We agreed to proceed with these facilitations, and we sent him. And if you're doing that in good faith, you are clothing him with some authority to negotiate, to accept or agree.
Counselor,
So
good morning. How do you respond to Brother Counsel's contention that most people realize that a settlement does have to be approved by a board? I mean, how do you, it is common sense, like when you're involved in these kind of cases, that there does have to be an approval authority. So isn't that just kind of commonsensical to look at it and realize that, okay, you know what? This is going to be subject to what the board says.
Sure, and I get to that. You're going back to, could they have authorized him to settle? Yes, they could. And in fact, if you look at the resolution,
How could they do that?
They could do it through, well, so for an example, if they had a closed session, and there was one in March of 2019 that specifically involved the Gould litigation. So let's say during that closed session, they had discussed and said, we will authorize you to accept anything over $400,000 during this mediation from the insurers. They don't go out and put it back on the record, on the open approval. They have given that authorization.
So it
They
would take a majority vote.
Right,
of the road
in the
commission.
closed session. If all three of them have said that, then there's authorization. It's in violation of the Open Meeting Act.
Is there another way that it could happen?
I think it could also happen through an email with all the board members on the email giving approval. That would also be in violation of the Open Meeting Act. Possibly then you could invalidate that decision. But also an important point on this, it's not
Do you have
automatic.
reason to believe it was approved either in an email or in a closed session?
I'm sorry, I didn't hear the start of your
Do
question.
you have reason to believe the settlement was pre-approved? That he was given settlement authority up to a certain amount, either in a closed session or by email?
Yes, I believe his email to the Citizens and Amerisher's Council suggests that is exactly what happened, that they had given that authority.
What did his email say?
Let's see. He says, John, his position is not correct, and I have an email from the former director, Mike Crane, of LCRC, approval of the $475,000 settlement amount in closed session.
So he doesn't say the board, he says the director?
That the director conveyed that to him. So if the board had told the director, yes, we are accepting anything in an amount of $475,000, so the truth is we don't have the substance of that email from Director Crane. we're in the course of probably getting that communication in terms of fleshing out this idea of was their authority given, even if in violation of the Open Meetings Act. And an important point that I do want to touch on, even if it was in violation of the Open Meeting Act, it's not automatically invalid. In addition to the fact that they haven't brought the case to invalidate it, it's not automatically invalid because there's a discretionary aspect for courts. They have to find that it violated the public's rights under the act. And I think there's an argument, at least there, that approving or authorizing an agent to settle litigation wouldn't be violative of the act because closed sessions specifically contemplate discussing settlement options and strategies. So you could have a closed session where you discuss settlement. You say, okay, let's accept anything over 400, and you go back out onto the record and say, we are accepting the recommendation of counsel related to settlement in the Gould case. And that if you do that, you aren't disclosing exactly how much you're settling for or agreed to settle for, or even what the recommendation was, but you are putting it on the record that you've accepted that recommendation. That would be, I think,
Without a
compliant.
public resolution or vote, or the statute the Presnell case talks about, you're saying they could privately agree to a settlement, and then it would not ever be subject to any public approval, or approval in a public meeting.
That they had authorized their agent to do that in violation, yes. It would be binding on
And that
them.
would be enforceable, so
It-
they could violate the law.
Yes.
I mean, could they
no.
run the whole county that, or the
So-
whole
so what
road
they
commission
could-
that way? Why
so-
ever go in public?
So this is an odd situation where they're saying that didn't happen, right? That's a situation that we're in. So what they could
Well,
do.
there's two things they're saying. I mean, I think they do say that didn't happen, but I think he's also saying that even if it did happen, it's not enforceable. We're
Right.
all on notice of the limits of the powers of municipal
Right.
officers and the road commissioners and how they operate and everybody who deals with them. I mean, you made a bit of a statement before that I found a little curious when you said just sending him to a mediation implies that he has authority to settle the case. So on behalf of the insurance companies you represent, you're telling our court that whenever you send your lawyers into court, they have full settlement authority on behalf of your insurance companies without regard to the adjuster being present or having any say-so in the settlement. The lawyers can just settle the cases and that's binding on your clients?
I believe
That's
there's
your
a
position today?
I believe there's a little bit more to it in that he sent them a complaint, invited the mediation. They've agreed that
You just said the fact that they sent them to a mediation suggested that he had authority. I thought that was kind of an absurd statement based on how your own clients operate every day in courts across, certainly Michigan, probably the United States.
Well, I
maybe the
certainly
world.
don't mean to be absurd.
Huh?
I certainly don't mean to be absurd.
I say that because as a trial judge, we couldn't do anything without the adjuster there. So I know how your client operates, and I think it's fine. Like it makes a lot of sense that the person.
And there's also a dispute about whether or not a representative from LCRC was there as well, which circles back to was that person authorized to settle? So again, I think, you probably understand my position, that this can happen.
Let me ask you this. Can there be apparent authority in this setting?
I think there can be apparent authority. I think there's at least a question of fact on it.
Based on a secret meeting?
The lower courts haven't really reached that point. Neither court really ruled on that. They're found a question of fact on express authority, so they haven't actually reached the apparent authority aspect.
Okay, so if I understand it, you're relying on your supposition that there was an illegal meeting, secret illegal.
But there may have been this agreement and authorization that was in violation of the Open Meetings Act. And I do want to touch on, if that happened and they aren't denying that it happened, then you're going to have a situation where somebody can bring that action to invalidate that agreement.
I don't know whether it happened or not. Part of what I'm raising my eyebrow at is why we would want to enforce the actions by a public body in a secret illegal meeting. That would be a strange precedent, as my colleague suggested. That would open up all sorts of avenues for government bodies to do all sorts of things
And
with friendly people that they want to help in the community that they don't want to put in front of a public meeting.
And I come back to the Open Meetings Act. It has specific express remedies in it, and this court said those need to be strictly followed in order to get the remedies under it. One of them is invalidating a decision. So if you're saying a decision is automatically already invalid, then there's no purpose in filing that action. That is a specific express remedy given in the statute that needs to be followed because the statute prescribes specific rights and liabilities and remedies. So if you're saying you get it without following it.
Is it just the Open Meeting Act? I haven't seen any reference to this, but isn't there a statute that governs public budgeting and expenditures, appropriations by public bodies, and how those appropriations are to be made?
I'm not positive about that.
If there was such a statute that said that the I don't know if it's applicable to, I assume it is, but I don't know if it is applicable to road commissions, but that said that they couldn't appropriate public funds unless they did that in a public meeting. Might that have an impact on this analysis?
And then if they don't, then somebody can file an action to invalidate it. To whatever they've misappropriated and they haven't put into the public record and put into the meeting minutes, somebody can file an action to invalidate that.
Well, I mean, yes, that could happen, but someone could also come into court and try to enforce it like you're doing, and then put the court in the position of having to make a determination of whether you're gonna enforce an unauthorized ultra virus, you're alleging, I think, an ultra virus act, they took an action that they didn't have the power to take, and you wanna enforce that.
I don't agree that it's ultra virus. So they can settle. They can authorize an agent to settle on their behalf. They have that authority, so it's not ultra virus.
But they have
The
to-
issue
they
is,
have
did they
to-
violate the act?
They
the
have to
Open Meetings
effectuate that
Act?
authority in a certain way, right? They have to execute it in a certain way.
And if they don't, it is you can invalidate it under the Open Meetings Act. If you don't do it under the Open Meetings Act, then it's not invalidated.
Okay.
The scenario that I think you're all picturing is sort of these, ill-intentioned smoky backroom dealings.
I think it's more that there's case law that suggests that when you deal with a public body, you're on notice of the limitations of their power. And so if they do things that exceed their powers, those aren't typically going to be enforceable against the municipality.
Well, and also, if they do violate the Open Meetings Act, this gets back to my point of it's not automatically invalidated. Even if you file that action, there are cases finding, yeah, it's a violation, but we're not going to invalidate it. So it's an issue that would be litigated. So for example, in this case, what they could do would be file a counterclaim saying, if you find that this authorization happened, we want to invalidate it, and then we can litigate that aspect.
So your view, I'm just curious about this, it shouldn't give us any discomfort at all, the notion that we would be compelling the road commission to disperse public funds that weren't properly appropriated. That shouldn't give us any discomfort at all.
If all three commissioners had given the authorization, or a majority of them had, no. Subject to someone bringing action to invalidate the decision. And a decision being made under the Open Meetings Act.
So if they do it in secret, it's okay as long as nobody complains?
I mean, eventually, if you enter into an agreement like this in secret, it's going to come out and somebody's going to file an action to invalidate it.
Well, what if it doesn't come out until after the?
Well, they have to put it in the meeting minutes to start the timeline in order to trigger the action to invalidate.
So how does it have to come out exactly? Well, you just said they don't have to approve it in a public meeting, so can't they just issue the check and hand it to somebody? When does it come out? I guess if you get access, again, you file a separate action and somehow get access to the county's records and expenditures and their specific
I guess there are
expenditures, and
numerous
find
ways
that
that
out?
people would find out about an
So
agreement like that.
if you just sit around and look at every check they write, you might notice this?
I guess. I can't tell you for certain how it might go into various
Seems like
cases.
a kind of a spotty system of checks and balances, but.
Sure, but it is how the Open Meetings Act is structured.
No, the Open Meetings Act is structured so that these things don't happen except in a
Well, it's
public
structured to
meeting.
give specific remedies and in specific ways to get them.
All right, I'm sorry, I'm giving you a hard time. Continue.
There's also the attorney-client privilege waiver issue. I'll touch very briefly on that. This court has adopted a flexible approach to that issue. The lower courts, I think, were very diligent in their application of that, constructing a very narrow remedy. Specifically, the production would be to the circuit court to review anything to determine if it's even relevant before it would even be produced. So I think that they've operated well within what the law permits in terms of a narrowly tailored limited waiver.
I'll give you one more question, just to let you speak on the attorney-client stuff. And it is, why shouldn't we think all you're doing is a fishing expedition and looking for whatever it is you're looking for to try to find something, anything?
We probably don't get this far without the email from the former attorney suggesting that he had authority, and there are emails.
Okay,
Thank you.
thank you.
Thank you.
Just 3 very quick points. One is the remedy that Brother Counsel is talking about deals with what the public can do, and there's time limits on it, and it gives the court discretion. The Lockhart case says a board can correct its error at any time, and that's important in this instance because it's the board that did not approve the settlement. And it raises a really good question. The whole idea of the Open Meeting Act is to give the public input. If they're bound by what they did secretly, what would be the point of the public showing up and say, you ought not to settle this case for these reasons? It eviscerates the whole purpose of the Open Meeting Act. There can be no possible good faith, in my view, I won't use good faith, proper argument that an attorney representing a board has apparent authority. There's no evidence that they've pointed to where anybody on their side thought he had apparent authority. They didn't even plead it. They know that they had already admitted in the pre-litigation correspondence that they were looking for minutes approving. And we all know what the situation is with an attorney representing a governmental entity. And unless you have any more questions, I thank you for allowing us to be here today.
Thank you. Thank you both. The case will be submitted.